Nicole. Good morning, everyone. Thank you so much for having us here. I'm thrilled to be here on this panel. I have an amazing panel with great experience on monitorships. Our topic is cross-border monitorships. We're going to talk about current developments and some lessons learned. And let me start by just saying one quick thing, is all of us have experience on monitorships. We're not going to talk about any specifics around monitorships because it's confidentiality issues, but we're going to talk more generally about lessons learned and issues we've heard. I'm going to try to leave time at the end for some questions, but let me quickly introduce the panel so you know who's up here. So to my left is Arnaud Collombet. He's a director at Forensic Risk Alliance's Parents Office. He is a very experienced external and internal auditor. He's a certified fraud examiner, a certified compliance and ethics professional, and a certified internal auditor. And most relevant to this panel, he worked on the monitorship team for IAV, which was one of the companies that worked with VW and was brought in as part of the Dieselgate scandal. So they had a separate monitorship from VW that Arnaud assisted with. Next to Arnaud, we have Ling-Ling. She is currently the Deputy General Counsel and Chief Compliance, Ethics, and ESG Officer, maybe the title right here, at Marrah, a company based in Boston. Prior to that time, she served as the General Counsel and Vice President of Ethics and Compliance at the Georgia Institute of Technology. For those of you who don't know, it's one of the most prestigious research institutions in the United States. And so she was the General Counsel there and handled all the ethics and legal issues there. Prior to that time, she worked at Panasonic North America. And again, relevant to this topic, she was the Chief Compliance Officer at Panasonic during their monitorship. So she comes at it from the company perspective. I think you'll find that very interesting to hear. Next to Ling-Ling, we have Preston. Preston is a partner at Crowell based in Washington, D.C. He has a wealth of experience as he was at AUSA in the Northern District of Illinois, Chicago. He also was the former head of global compliance and investigations at GE Healthcare. So he has the in-house experience, and he's been on numerous monitorships, including for the U.S. District Court in Chicago, the Waterfront Commission of New York, New Jersey. I'm sure you have some great stories about that that you want to ask about when you have a chance from Preston. And he also has served on the ABA Criminal Justice Section Council and was one of the people on the task force that Bill mentioned about setting standards. So he has a wealth of experience in this area. And finally, but not least, on the end, we have Nicole Willms, and she is a partner at Pohlmann Company based in Frankfurt. She is really a leading expert in terms of developing, implementing, and testing compliance and ethics systems. She has worked on 3 major monitorships, so I think that's a pretty important distinction. There are many people who would say that. Where Nicole was an executive member of the independent monitor team for the DOJ and SEC at the Wimpelcom, then Beyond matter. She also worked as the German counsel for the VW monitorship, which is where I worked with her. I worked on the VW monitorship as the deputy monitor. So I have a lot of experience with VW with her. But she did that, but also currently she's serving on the executive team for the independent monitor for the Ericsson monitorship, which you probably have read about. So with that, you can see we have great monitorship experience here on this team. And I'm, as I said, thrilled to be here with all of you. So let me start by talking a little bit about current trends and what we're seeing around the world. And if I may start with you, Preston, if you could tell us a little bit about what you're seeing. I mean, one of the things that was talked about in the very first I guess it was a fireside chat, not a panel, with the enforcers, was about all the DOJ guidance. But one of the important areas of guidance from the DOJ was on monitorship. So maybe we could start there if you could for us.
Thanks so much. So it is a pleasure to be here. It is a real pleasure to hear the ABA standards get mentioned in this forum. Thank you for raising that, because it is a real treasure of knowledge from different spheres on what monitorship should be. And I think there's actually an opportunity to update that going forward. As we look at what the current trends are, there's a quote from a guy who was famous around here that I think really applies, and it's what's past is prologue, right? That's Shakespeare, of course. And the reason why I say that is because we can't think about what monitorships are now, where they're going, without remembering where we've been, certainly over the last 14, 15 years. we have to think about, when it comes to the Department of Justice, for example, when did they start really releasing standards on what a monitorship should be? And that starts, of course, with the Morford memo. Probably some of you are familiar with it, which really tells us how monitors should be selected, and then also how they should be used. We'll go into that in a second. But then historically, after Morford, there was Brewer in 2009 and Grimler in 2010. On the civil side, Dellery in 16, Bensikowski in 18, and now Monaco in 21 and 22. Again, we'll touch on those. But the reason why I go through all of those is because Morford is really the one that spends the most time laying out the bedrock principles for how we use a monitor and what a monitor should do, at least within the department. The Morford principles discuss things such as a corporation and the government should discuss the necessary qualifications for the monitor. A monitor is an independent third party, not an employee or agent of the corporation or government. That one is, in particular, is important because those of you who are familiar with monitorships may know that from time to time the question about attorney-client privilege comes up, right? And whether the monitor's work papers and discussions that they're having with the company should be subject to media scrutiny, for example, or just other outsiders. Another principle from Morford is, monitors' primary responsibility should be to assess and monitor corporations' compliance with those terms of the agreement that are specifically designed to address and reduce the risk of recurrence of the corporation's misconduct. Now, why would you say that back then? One of the reasons you'd say that is because one of the fears of monitorship is scope creep, right? And so we want to make sure that we're bringing the monitor in for a company and that the monitor's going to do it as they were, as it was designed, right? Per the initial discussion with DOJ. We don't want a monitor to come in and feel that it is their remit to find everything that is wrong with the company and then to report on it. The Morford memo also talks about a monitor will often need to understand the full scope of the corporation's misconduct and really, truly digest it and address and reduce the risk of recurrence. Again, some similarity to the last one. Here's one that is tricky, and it's one that I think monitors deal with today. If a corporation chooses not to adopt recommendations made by the monitor within a reasonable time, either the monitor or the corporation or both should report that back to the government along with the corporation's reasons. Now, why is that tricky? It's tricky because, on one hand, as a monitor, what you're trying to establish is a cooperative relationship. But if you have to point your hand at the company and say, you know what, they're not doing what they're supposed to do, which is often the case, then it sometimes becomes an adversarial relationship, which then sometimes results in a need to figure out how we're going to resolve that discontent. There are other principles as well. One of them is if the monitor finds that the company has engaged in misconduct before the monitorship came up, that misconduct is relevant to the scope of the engagement, then the monitor needs to find a way to disclose that to the government. That too is a big deal, and really carries a real risk for the company if the disclosure that the company did was not complete. So those are some of this is 2008 Morford principles. And then there is a real dividing line at that point where the department focuses these other standards that I've raised. It focuses more on the selection of monitors than the use. And the reason for that is, or one of the reasons, is this article right here. Back in the end of the 2000s, Christie appointed Ashcroft to a monitorship for Zimmer Environment. So to cut the story short, Ashcroft and Christie had a relationship, and Christie was the U.S. Attorney for New Jersey. Ashcroft was the Attorney General. They may have known each other through other ways, but at the end of the day, what Ashcroft sent as his proposal to the company for the monitorship was a one-liner that said $52 million. Lots of congressional hearings after that, and there's been a lot of focus on how do we curb that type of abuse. And frankly, as monitors, we've been fighting that ever since then, and it comes up all the time. So I'll get into other standards in a bit. I don't want to take too much time, but that certainly kind of tells you where we've been. We're now at a point today with standards from Lisa Monaco that speak to selection, diversity, and some other things that are important in the selection process.
Thank you, Preston. And if I could turn to you, Nicole, let's move down to the EU first, and you can tell us a little bit about what's happening in the EU.
Yeah, I think, thank you again, also from my side to be here. I think the EU, as we heard this morning, cannot be kind of put in one place. Very, very different states, very different approach. Germany, from my home country, we have had a lot of companies under monitorship. Some of the famous ones, I would say, Siemens, VW, Deutsche Bank. However, we have no institute comparable to something like a monitorship. Maybe that's why we kind of are so happy to get some of the US ones. But I think the main reason for that, why Germany kind of does not have any of those, is because we also have a very different, almost non-existing system of corporate criminal liability. So we still have no kind of real corporate criminal liability enforcement as comparable to the US, to the UK. There is certainly fines and discussions around fining companies where executives have been involved in wrongdoing, but it's not comparable to what has been built in the US, including the settlement proceedings where monitorship comes into place. And actually, because some of the reasons that you just mentioned, because Germany has always encountered these monitorships to be intrusive and expensive and cultural clashing, recent discussions around introducing corporate criminal liability and introducing an institute comparable to monitorships failed during the last legislative period. We're wondering whether it's coming up again, but it's still not, so we'll see. We see some interaction on the EU level. There has been just recently, in May 2023, there has been a new draft of an EU directive for combating corruption, which includes obligations for member states to introduce a certain criminal liability enforcement regime. So for Germany, that would mean a lot compared to other of the European countries, which are much more closer to what has been provided by the EU there. It's not yet clear what comes out of this draft. It, however, includes a sentence that criminal enforcement and sentencing and settlement might include placing the legal person under judicial supervision, whatever that means. We'll see. I think finally, sometimes you hear about BaFin, the German financial regulator, to send someone comparable to a monitor, special auditors, Sonderprüfer in German. That is more of a supervisory kind of nature. It's much more investigative. We come to that probably in a minute, talking about the standards. It's much more looking at certain complaints and then for the special auditor to look into transactions, anti-money laundering, compliance processes, etc., checking whether they are valid or not. But it's not comparable to what we kind of know from monitorships under the US. I'm not kind of the right person to speak a lot about the UK. We had some here this morning. But at least there we know that there is a regulatory statutory regime on settlements, which include the potential to also impose monitorships on corporations. However, we have seen only a few. Pipeline seems to be full. We've heard this morning, and not necessarily for monitorships, but maybe also. I think in Germany it was always the discussion that there is no real statutory regime that would govern all the problems that you just raised. I think in the UK there is a statutory regime, and I think we learned that also imposing a monitorship has to stand court approval or court review. Maybe that is a reason why it has not made so many monitorships in the past. I don't know that, but that's what I can see in the EU.
Arnaud, if you could comment a little about how these concepts are affected in France. Tell us a little about that.
Absolutely, thanks, Scott. So when it comes to France, monitorship is something that has been recently introduced, which is used, especially in the corruption space. So if we go back to 2016 and the Sapin de law, which was passed, which is the French anti-corruption law aiming at aligning French regulation to the international standards and best practices. This law established the French anti-corruption agency, so the AFA, and the AFA has mandates with the different dimensions. One dimension is basically advisory, delivering guidance, issuing policies, etc., but also a control function. And this control function is twofold. One is preventive control of companies of certain size who should have implemented defense programs. So the AFA will come to them and check whether or not they can. And then the AFA is also responsible for controlling the execution of court-ordered remediation plans. So this is the monitorship side. Since 2016, if we speak about statistics, we had approximately 25 French DPAs pertaining to corruption, and 8 of them got a monitorship attached to the resolution. If we compare to the preventive control function that the AFA is doing, the AFA is performing 30 to 40 preventive controls a year. So the French authorities still prefer to go on the preventive side than the resolution side. Maybe some specificities compared to the US. So we've heard that in the US the monitor should be an independent third party. In France, for corruption, the AFA will always be the monitor. So the agency will be the monitor. Of course, they can rely on external support, but the ultimate monitor will be the agency. And second, the cost of the monitorship in France will be capped and will be specified in the DPA documentation, which is something also very specific compared to other jurisdictions. Maybe two or three elements for the recent developments. In 2022, there was a DPA signed on round of aggravated tax fraud, to which a monitorship was ordered, and the AFA was appointed as the monitor for this monitorship. So this is the first ever monitorship on tax issues. So we'll see how it goes. And in 2023, the Financial Prosecutor's Office issued new guidelines, in January earlier this year, in which they detailed the dynamics of the French DPA and also the calculation of the penalty to be applied, listing a lot of minoring and aggravating factors. And as part of the aggravating factor is the absence of a robust compliance program, leading to or getting us closer to this failure to prevent that we can see in some other jurisdictions. And last but not least, in summer this year, the AFA also changed management, so they got a new director. We'll see. We're looking forward to statements she will make on which orientation she wants to give to the AFA actions. But we can anticipate, given the guidelines, given the new tax-related monitorship, that this is a growing and increasing topic in France.
Okay, thank you. I want to come back for a moment to the comment that what Preston said earlier about how Department of Justice, we've gotten more guidance, and then the current Deputy Attorney General announced essentially a reinvigoration of monitorships, and that we expect to see more. We've seen a few in the United States, and we keep hearing the word pipeline, I think that Nicole used, and that they expect there'll be a pipeline of additional monitorships. And so one thing we want to talk a little bit about is again, back to what Preston said about the expense. If you represent a company that has a major issue involving U.S. authorities, and as you heard earlier, likely other authorities, they're looking at a number of things to determine whether it has to be a monitorship. They're looking at the seriousness of the offense, the pervasiveness of the misconduct, how high it up went within the organization. Things like the real key is remediation, looking at what's happened to the company and whether they made enhancements and testing their internal controls and their compliance systems, things like that. And that's all part of the discussion with the DOJ early on when a company's looking to resolve their serious investigation. But I think it's helpful to maybe hear from Ling-Ling's point of view. If you're in a company going through that process, like what are some of the things you're thinking about that can be done to try to either prevent a monitorship, if you want, or to make sure that the scope of the mandate is very limited to specific issues. Can you talk about that a little bit?
Sure. Thanks, Scott, and good afternoon, everybody. As Scott mentioned, I was the Chief Compliance Officer at Panasonic during our monitorship. And so what happened at the company was in 2018, Panasonic consented to an SEC order and also entered into a deferred prosecution agreement with the DOJ for FCPA violations relating to their global avionics business. And when these issues were detected, we quickly sort of assembled a team to help us work through this. But I completely agree with Scott's earlier comments. The moment the government starts investigating your company for alleged activity, they're also evaluating your current program, and they are at the same time trying to determine if the company has truly understood the severity of the issues and has appropriately invested in what needs to be enhanced to ultimately avoid the likelihood of this happening again. So it's very important that you as an in-house lawyer is translating to your company leadership that now is not the time to try to save money, even though we know that we're going to be end up paying quite a lot of penalties. Now is not the time to try to budget. We really need to pour a lot of investment into trying to avoid the monitorship if possible, but primarily to investing in the infrastructure that will avoid this from happening altogether. So the remediation plan is very key, and I'd recommend that you not try to do this completely internally. I think it's a demonstration of confidence to the DOJ if you engage a very well-respected, well-regarded consulting firm to come in and help you phase the remediation plan, so it's taken more seriously. And so during the time of the investigation and even during the monitorship, we lived by spreadsheets that were color-coded, red, yellow, and green to show our progress and all the efforts that we were trying to make certain enhancements. And that's going to be very important. And those were shared with the government to demonstrate the fact that we're not just saying we're going to remediate, we actually are doing it. Here's what we actually have done, here's what we've completed, here's what's in progress, and here's what we have going on for the future, but we hope to complete it by X date. Having those very specific sort of timelines in place is really key. I think discipline is a very important topic here as well. During the investigation, the government again wants to see that this is something you've taken very seriously. So you have to have, as an in-house lawyer, the conversations with your leadership team about what is the appropriate, effective discipline in this situation. Again, not only to avoid a monitorship, but to demonstrate that we have learned our lesson. And I'll talk a little bit later about the cultural components of that, because Japanese companies operate very differently from Western companies, especially when it comes to things like disciplining employees. So I think making sure during the selection process, and we'll talk more about that in a minute, that you're finding a monitor that really appreciates that is critical. It's probably one of the more important criteria when we went through that monitor selection process.
That discipline point is excellent, and we could do an entire panel probably last night at dinner. We talked a lot about discipline, how the rules are so different in different countries, and how a lot of times the prosecutors, because of the sharing we talked about earlier, they understand, but it's still difficult to understand sometimes the issues in countries, what the company may face in terms of challenges of discipline. So let's now say you represent a client with a major issue. You've done as much remediation you can, but still the Department of Justice is insisting on monitorship. Just at a high level, I think most of you may know this, I'll say this very quickly, but that the process in the U.S. for selecting a monitor is in some ways surprising to people who don't understand how it works, because the company gets proposed, in the first instance, 3 candidates, and then the Department of Justice selects the candidate to be the monitor. And so there's some give and take there, where you have the company selecting, but also the DOJ selecting. So when you're trying to be a monitor or be part of a monitor team, you're kind of selling to both audiences of how you will be the right choice to both understand the issues that Ling-Ling's talking about with the company, but also you have prosecutors who spent a lot of time, a lot of their lives invested in this investigation. They want to make sure the monitorship team does it the right way and that they get out of it what they want to get out of it. So maybe we'll start with you, Nicole. Can you talk a little bit about when the monitor team is looking to be selected, that process, what you look at and what you've seen?
Yeah, and as you said, I think it's a dual pitch. And first of all, you need to be on the kind of short list of the company. It also includes, as Ling-Ling said, traditional settlement counsels who are used to work until this stage and recommend firms for kind of becoming a monitor. So when we were approached, we always were approached first by the company and their counsel, and you start kind of doing your pitch there, which includes, as you said, independence. It's when we worked on the VW case, for example, you can imagine it's not easy for a German firm to state that you have no one on your team who has worked for Volkswagen or any of its subsidiaries within the last 3 years, and then you also need to commit that you wouldn't work for them 3 years after finalization of the monitorship, right? So you need to get your team in order, you need to check your independence, because that is, one of the fundamentals. You don't want to start going into the process if you can't make up for that. And then secondly, you really need to dig into what the company, is up for. What's the real problem there? When we went to the interviews, it's a lot about, talking general requirements, the standards that have been written down in a lot of the memorandums for the first half hour. But what really matters then is to what extent you can really show that you understand, where the company is, what the company needs to do next, how far they got with their remediation process, how far they got with improving their compliance systems, their controls, but also, where the root cause of what happened really was. Is there a particular country? Are there particular cultural discussions that you need to take, and maybe it's the organization and the organizational setup of the corporation that makes it difficult to now show to DOJ that you have improved and that you learned your lesson. So you really need to dig into the company's organizational setup and wrongdoing to have an engaged discussion on that, because you're pitching for being like a forced marriage. You will be with this company for 3 years. So you need to make sure you kind of get a connection in these first discussions. And part of that is also budgeting. I think you talked about it, and I can really say in all the meetings we've been, budgeting is a major issue, because the companies all have what you said is clear about, that someone has just put the cash machine into the office, and that trillions of employees and sub-engaged parties will come and learn on the job, and you will pay that, and you have the first-class flights from the US, and you have all these rumors and discussions around, it doesn't help you, it just costs you. You really have to address that very early on, and it's, from my experience, we have never had a discussion that was free of the budgeting discussion. So I don't think you can come now as a monitor and just quote a sum and then kind of rely on to be selected. And that forms true also for the government. So next step, if you make it to the short list of the company, you certainly have to make your pitch to the government. And as I said, independence is a kind of important issue. Secondly, understanding of your role as a monitor is important because the authorities, know about some of the, aspects that Preston mentioned. You may have to, notify some things. You may have to talk to DOJ about, things that you discovered. But in general, you're not an investigator. You really have to understand compliance work. How does a corporation work? How are the processes, to be tested? What is it that a compliance program makes it become effective rather than just a paper program that, all the companies have at least put in place during the settlement arrangements? So really kind of providing your compliance background, your understanding of companies and how they work in-house has always helped us. We have a lot of previous in-house people on the team, so that kind of gave us some credit, I guess, in the past. And again, also the government has started to ask about budget restrictions. Where do you focus your team on? How do you limit on-site traveling? How do you, we started our current monitorship during COVID. How are you thinking to address that? So you really kind of need to be prepared for having a lot of procedural discussions, not only about whether you're good friends with any of the persons that may have given monitorships in the past.
Preston, can you comment on that too?
Yeah, just very quickly. So we talked about trends in the past. One of the things that's been discussed with the department is the Department of Justice stood up something called the Corporate Crime Advisory Group. And there's been a lot of different things that that group has put forward. One of them focuses on, as we said, the monitor selection process. I was part of the outside group of I guess, professionals who were part of that group. And in our discussions with the department, one of the things that we raised, and this was back, I guess, in early 2022, is that when we talk about the selection process and what it is to develop this connection that Nicole talked about, here's the reality. Especially for monitors that have been maybe recommended, let's say the DOJ recommends a slate of 3, or another agency recommends a slate of 3 before the company comes up with that. You go in, you interview with the company, you tell the company about how cooperative this process is going to be, how gentle you're going to be as a monitor, how this is going to be really create a lot of value, and it's not going to be, it may be a little bit disruptive, but we're going to do the best we can to make sure that you are not overly disruptive. And then on the other hand, when you're before the department, sometimes that dialogue changes. Sometimes the dialogue is, we got to get to the bottom of this. I can't believe they've done these things. Who are the targets that you didn't get to in your investigation, who you need to look out for. And so what you have is kind of a duality of the conversation. Now, we said this to the department. I think the department is looking at a way to solve that. But when I was the monitor for the Waterfront Commission, I went in for an interview with my team with really the most important person at the company who had just come out of jail because he had an association with the Gambino family. And the purpose of the monitorship was to make sure that the company no longer had a relationship with organized crime. You can imagine how that conversation went. He was at the end of the long table in New Jersey with smoke around him. Here I come, from Chicago, who's this guy? You talk about a duality of a conversation, right? One that you have with that guy and then one that you have with the regulator when you're telling them, what you're going to focus on. It all boils down to, I think, really both company counsel in-house counsel, and the government needing to really coalesce around the work plan, and the fact that the work plan will evolve. But I think that we need to figure out a way to maybe get everybody in the room so that there's not such of a duality of conversation.
I knew you were going to have good stories from Marrah Commission. I knew that. So let's talk from the company side of the line, if you could. What's that company thinking about? I think there's a lot of talk from the lawyers who want to be monitors or monitor teams. But what's the company thinking about in that process? Because it's a really unique vantage point.
Sure. It's interesting to hear about the dialogue potentially changing when you're in front of the government. I was always very curious after we
We said the same thing. Always the same.
Yeah, well, I was very curious after we did our interviews with the proposed monitor team, what they were saying, to the government. That could be a fly on the wall and go back in time. I'd love to know. But I think it's also very reflective of this collaborative approach in that when the monitor is selected, not only do they get the opportunity to speak with the company, but with the government as well, because I think ultimately the goal is shared, and that's creating an outcome where the company is in a better position, has better resources, and is better positioned to not have these issues once again. But in our situation, if I recall correctly, we interviewed, I think, 8 potential monitorship teams, and then selected 3 that we felt comfortable with, and sent that list to the DOJ, and then waited several months for them to come back with the appointment. But in the interview process, there were several criteria we were really focused on. One was prior monitorship experience. It wasn't a deal breaker if they didn't have prior monitorship experience, but why that was an important criteria is that we wanted to be sure that the monitorship team wasn't going to reinvestigate the concerns that have already been investigated, and that they were going to take a forward-looking approach and really focusing on remediation. And those who've had monitorship experience tend to understand that a little more. Prior experience with the DOJ was an important criteria. Ideally, we would like the monitorship team to have folks on the team who actually had, walked the halls of the Department of Justice before, because we felt that would help make it a little bit easier to communicate back to the DOJ about the progress that we're making, if they could sort of speak in their language and engage those people, already. That was an important criteria. We talked a lot about geography. Our global avionics business was headquartered in Southern California, so having a monitorship team that at least had a presence or an office in that area was important for us just for logistics. And cost. Obviously, this is not a time to try to get a monitorship on a budget, but typically the company pays for the monitorship, so that was an important criteria for us just to understand what their cost structure was going to be. And then I think we talked a little bit about cultural fit a little earlier on. This was incredibly important, probably the most important component of our interview process. And that's because Japanese companies, as I said earlier, do operate quite differently when it comes to things like discipline and decision making. And it was very critical that the length of time that sometimes these things take within a Japanese corporation weren't going to be misinterpreted as us being uncooperative. So by way of example, in terms of discipline, when we talked about we want a company that's familiar and understands Japanese culture and understands Japanese business, it wasn't as superficial as we just want them to have had a client who worked, who was a Japanese company or had spent some time in Japan. They really had to appreciate the challenges that we were going to face. A few years earlier, the DOJ had launched an investigation in the automotive supply business regarding antitrust issues like price fixing and bid rigging. And Panasonic also was one of the companies that was involved in that particular issue, along with, I think, 21 or 22 other automotive supply companies, mostly Japanese, but there were a few European companies in there as well. And there was no monitorship in those particular issues. But what I think demonstrates, I guess, the flavor for the different cultural challenges here is when several Japanese executives were sentenced and they entered jail, the Japanese companies viewed those employees as soldiers who went into battle and who got shot. And so they had to go to prison, and while they were there, the company really rallied behind the families and said, "Don't worry, we're going to take care of you." And then when those Japanese executives came out of prison, they were hired back into the company and promoted. You know, a demonstration of, you know, thank you for your loyalty to the company, you know, you took them for the team. This is a completely different sort of view and perspective when you look at Western companies where they would immediately fire the executives and they would completely sever all ties and never again speak of their name. So it's a very different approach to the way individuals are regarded within corporate structures. It's very value-based, very family-based, very relationship-based. So having a monitor who can understand that's where we're coming from and help us describe that more successfully to the DOJ so they can understand that the enhancements that we've made have been within the framework of this very unique cultural construct. So cultural fit was important for that reason. Because we didn't want a monitor to come in and immediately apply sort of Western principles to our corporation that was still sort of trying to struggle in terms of translating this internally and helping the executives understand where we have to kind of meet the government. So that was important. And then diversity was important as well. It was in the mandate from the DOJ in terms of the selection of the monitor. And you know, there are a number of stories there. I don't want to call out any firms for specific things they did, but in general, I would just say make sure the people who come to the interviews are actually going to be the people who are going to work on the monitorship, and that you're not putting people in that panel to show diversity when they're clearly not qualified or, you know, not planning at all to work on the monitorship over the next few years.
Thank you, Ling-Ling. And one thing I think it's really, obviously that's really important, but the shared goal point you made. We had when Nicole and I worked together on the VW monitor, it was under Larry Townsend, who was the monitor, but his theme throughout was shared goal to make a better company. It's amazing how just having that very simple message can resonate with both the monitor team and the company. If everyone's coming together to improve the company, it can make it a whole different feel, I think, of the experience. But touching on your last point, Ling-Ling, I think this one of the key points of the guidance from DOJ is that we referenced a couple times for selecting monitorships. This time, the new guidance talks about a team, not just the monitor. So in the past, we've talked all about the monitor, but now the guidance is talking about the team, which is a really, really important point because it's more than just the monitor. And Arnaud, if you could start with that, talk a little bit about key considerations when building a monitorship team. So you have a great monitor, that's wonderful, but how do you build a great team around that monitor?
Absolutely. So we already spoke about independence, obviously about cultural fit. Also important is the fact that compliance monitorship is not only done by compliance people. So the team that you will have to supervise the monitorship should be integrated in the sense that people have the knowledge, but in common to be able, the capability to supervise the monitorship. Meaning that, of course, you will have legal people, compliance people, but when we come to testing, typically, you would need also internal control specialists, you would need audit specialists, you would need investigators, you would need people who have various backgrounds to be able to cover all the aspects of the monitorship. I mean, compliance monitorship is super diverse in terms of components, you know all that by heart, but you need people who collectively can cover all these aspects. Important as well is the data privacy experts. As a monitor team, you will request hundreds of thousands of documents, review them, and the team who will review all these documents will be based all around the globe, obviously. So if I take the example of the monitorship I worked on, was a German company, and we had colleagues working on it from France, from UK, from Switzerland, from the US, and you need to navigate all the challenges, the data privacy challenges from all the national and the supranational regulations. So typically, if it comes to Europe, you have all these GDPR topics, you have potentially the working statutes topic. In the middle of the monitorship, we also had the Brexit happening. So what do we do with the UK? How do we consider Switzerland in all this web? So data privacy is a real important topic. And the solution we basically came up with and we offered the company was to have several data rooms where people wouldn't access the same information, or they would access the same information but differently redacted, depending on whether they would be based in the US or in continental Europe or the UK. Another topic is obviously for the team, the experts you need. You would need industry experts, obviously. You would need people who are able to have a technical conversation with the employees of the company. So again, on this monitorship, and I can recommend the experience, it's really interesting to have a discussion about test benches and lambda sensors with a German engineer. But it's even better if you have an expert who actually can understand what the employee is saying. So, and this is the same for banking. You will need bank expert if the monitorship is on a bank. So, again, the team should have this collective knowledge. And the second important point is obviously language. Of course, if you go to corporate functions, to headquarters, you can assume people will be able to have the conversation in English. But if you come to some components like the corporate culture, you would want to reach out to people from every hierarchical levels in the organization. So you would have random employee, not necessarily able or willing to speak in a different language. So make sure you have in your monitor team enough native speakers to be able to cover that aspect. Of course, if you can't do otherwise, translator is a solution. It's probably not the best because it slows down the flow of the conversation. But yeah, again, best option is really to have native speakers. And of course, since companies nowadays are really global, you don't want to look only at the headquarters, so you would go to the subsidiaries. It's plus to have, as Ling-Ling said, a coverage, a geographical coverage in the jurisdictions where subsidiaries are located, or having people willing to travel.
That point about native speakers is a great point, because there are so many times when you are dealing with these cross-border partnerships, it's very easy for someone to say a word that is maybe close to that word in English, and it's not exactly what they meant. Having native speakers there to say, well, Scott, they didn't really mean that, they meant this, and it helps you stay on track. That's a great point. Do you want to comment on that, Nicole or Preston, about putting the team together?
Yeah, I can only kind of confirm what Arnaud said, right? I think the diversity in many ways is very important. The language issue, I still remember on the Wimblecom monitorship, we went to all the East European countries, including Russia and Ukraine, and people there explained to us that there is no Cyrillic word for compliance, right? And if you go to the line of sample randomly selected interviewees, they feared sitting with us, right? Like, this was not an easy conversation for them, so it was not even thinkable to do that in English. No matter how good or capable they would have been, it was very important to bring someone who was part of our team, who was not only translating, but really understanding where we want to go, in order to facilitate a trustful conversation, not only exchange of facts. It's also important if you test, that's just an anecdote, but if you test the whistleblower hotlines, you also need some local languages. There's a lot of good and funny things to invent when you call them. We once called a number in one of these earlier days where we ended up with a sex hotline. But I wouldn't have understood that if but we had, as I said, Russian-speaking natives that told us, actually, that must be the wrong number. It was obviously a wrong link, but no, I think you really need this diversity to build the a relationship with the company, that you understand what they are talking about. And that doesn't fit only with translation.
Thank you. So the monitorship is now, you've got your team, it's going forward. Ling-Ling, can you tell us from your perspective, from the company perspective, what are some of the keys for that monitorship being successful? Are there some things that stuck out from your experience?
Yes, I think a very good in-house lawyer understands that they're a business person first who just happens to have a law degree. And so we've hired law firms to sort of navigate through this monitorship experience, but my role is really to be that communicator back to our board or employees so they understand what this is all about. It's critical that the monitor has confidence that our program and our culture change is sustainable. And I don't mean ESG, climate change sustainable, I mean it will survive the end of the monitorship. The analogy is like when you're teaching someone to ride a bike and you're standing behind it and you're pushing them along and then you let go. You don't want the person to fall off the bike, you want them to continue and you want them to pedal and keep going. And that's really what I try to communicate back to the leadership team is that this is meant to be a process that leaves us in a better place. And it has to be sort of repeated over time because the monitorship can get really intense. There are times that they're testing controls in a way that seems excessive. It seems very easy for the company to become quite defensive. It's like, well, we already did all these things and you're still saying it's not enough. So you have to re-communicate back to your leadership team that again, this is to ensure that we have what it takes to continue doing the right things. And I think the communication is not limited just to the leadership team because the change has to be sort of systemic and throughout the organization. So you have to use other opportunities as well to explain to employees in language that they understand what's going on and what's being expected of them. So opportunities like town halls and other sort of business meetings that are meant to communicate where the company is headed is a great opportunity to also leverage to explain where we are in the monitorship process, what is this all about, because employees will ask, they're like, who are these 5 random people running around the building asking me for documents and, asking me all questions about myself. So you have to make sure they're prepared and kind of understand the context there, so that's really key. And then I think if you can make sure you have a really effective program management office to manage this monitorship alongside you, that's going to be important too. It's impossible for just the legal team or the compliance team to ensure that the company is doing what they need to be doing in the context of monitorship. It has to be sort of a collaborative effort. And there's going to be lots of documents requested. There's going to be lots of meetings that have to be scheduled. There's going to be lots of language issues, as you alluded to earlier, so you need to make sure you have your interpreter in place. All of that's going to be really important that you have already done on the front end to make sure this is not going to be a painful, too painful of a process.
So I'd love to hear all three of you really comment from the monitor team's perspective, what are the keys to success? So maybe I'll start with you, Arnaud. Some keys to success that you see for the monitor team.
I think for the monitor team, the most important is to be visible, to show presence. This is important also to demystify all the rumors that we talked about the monitor. So, as Ling-Ling said, for the company, it's important for the manager to address the employees during town halls, during meetings, to shadow meeting, explaining potentially why they are in the meeting. That's very important. That's also important for the monitor to have a successful monitorship, to engage with the powerful people within the company. So it's not necessarily the top management, could be middle management. If I take the example of Germany, the employee representatives are very powerful, so it's important that the monitor also reach out to them. I mean, in the end, the monitor wants to establish this trustful relationship with the company, and it's important to show what the monitor is doing and why. On the other hand, I think it's important that the monitor make sure the company understands that the efforts of the company are for the company itself, it's not for the monitor. The company is not working for the monitor there. The company is working for their compliance program, and when the monitorship is over, the compliance program should continue, should be sustainable to continue working. So that's, I would say, the two main elements important.
Preston?
So, yeah, this is an interesting topic. First, from a monitor standpoint, my goal is to end the monitorship early if I can, right? I want to get the company to a place where it has a compliance program that I've got confidence in, and the team has confidence in, and more importantly, that the department has confidence in. Now, that doesn't always happen, but it's key. I have to go back to what Ling-Ling said. If we were able to video what you just said and give it to companies when they're going into a monitorship, that would be a real key to success, because the way you just described what the company's mindset should be going into the monitorship is something that frankly you don't always encounter. Sometimes a company wants to fight. Sometimes a company wants to be adversarial. Sometimes a company doesn't want to give you documents. And what does that mean? That means that my goal of ending monitorship early, right, is not achievable, because we wasted time fighting when you've already brought me in. You already made a decision to bring in the monitor, so why are we fighting, right? So I really commend them for what you said. The other thing I really would ask everybody that you can go right now on your phones and find it. You want to find keys for success from the company side, from the monitor side, from the government side. Those APA standards are really a great source for you to kind of see. We've got folks from the Department of Justice, folks from New York City. Ron Goldstock really started this whole field in New York, and former judges, former U.S. attorneys, and so forth, and myself. We all came together over a year and a half, and we've been talking about what are the keys to success. They're all written down. And so you can literally find those on your phones right now.
Still like the original system.
Yeah, I think you're right? I think companies would do really good in preparing for this situation that the monitor comes at. Because I think it's understandable. A lot of people have gone through a lot. You know, you have all these investigation times, you know, you had the settlement, the company's heard, it paid a huge fine, and then there comes the monitor and it's meant to stay for 3 years, and he has tons of requests. But I think, as Ling-Ling said, you know, preparing as much as possible for a cooperative relationship is key, because it makes really good use out of the time. I think not rarely, for example, the data protection issue that Arnaud mentioned, you spend the first 180 days to discuss how, you know, who redacts documents in which, you know, dimension, and, you know, and you also need to explain the monitor that this is not meant to be obstruction of justice, right? It's really, you know, cultural changes and cultural differences in data protection. And when I'm going around in Germany, I always wonder why companies do so little in really exchanging lessons learned with those that have gone through this process, right? What worked, what didn't work? Why is it so hard to, you know, really try to learn from mistakes or good things that other companies have made during this time? And the same is true for the monitors. I think it's important that they work with these standards, that they exchange what has worked and what didn't work. I personally think, you know, looking at all these cultural aspects that Ling-Ling said is key, right? You don't get a monitor because you haven't fixed your policies or you have a bad whistleblower system. You get a monitor because you have, most of the time, you have real deep issues from a cultural perspective, or you have just put up a compliance program in a rush and you haven't tested it. But that means it's quite a long period that the monitor needs to finalize this with saying, I've tested it, it works in practice, and it's meant to be sustainable, right? And if you spend the first part of the monitorship with fighting, you lose a real lot of time implementing and working on these issues so that the monitor can still test it at the very end, right? 3 years sounds a long time, but if you want to do a cultural transformation, if you want to fix or include compliance factors in your overall incentive system. You know, think of this. You start designing that, you put that in place, and you are already in year 2 of the monitorship, and then the monitor wants to see this working. So it means you're already in the 3rd year, and that requires you to tackle this particular issue in the first 3 or 6 months. So you really, as a monitor, you really need to focus on what is key in that particular situation, and not necessarily fixing the COI policy. Again, third-party review and relationship tools, implementing that in the entire sourcing and supply chain, and then testing it for working in practice. This is not a year thing to happen. And there's a lot of effort in the beginning of getting to know each other, trusting each other, coming over these fights, which is missing at the very end of the monitorship. So I really believe that for both parties to try to look for what is the goal in this from the very first day and to prepare as best as possible is key for success.
Thank you, Nicole. And I will say that's one theme we hear from the DOJ consistently is the testing point you raised about testing.
Yeah.
We want to know that it's effective in operation, not just designed effectively, but operating effectively. That's a real key. So we were going to talk about one of the new things that DOJ has done now too is having CFOs, the CEO and the Chief Compliance Officer sign off on the agreements. I'm going to skip that just in the interest of time, but something to be thinking about. It's created a little bit of controversy in the U.S. because people are afraid it's putting the Chief Compliance Officers a little at risk, but there's also obviously a lot to be gained by having people like that sign off on what's happening. So that's maybe something we can talk about with you for fun if you find this as fun as we all do. But I want to get to the last point, because I think this is something that you all might want to hear, which is what this panel thinks are the trends. Like what will they be seeing in the future? So a lot of monitorships in the U.S. at least have been based on the FCPA and other related issues. But I think that's not necessarily going to be what all we're going to be seeing in the future. So I want to hear your thoughts in terms of what you think may be coming in terms of where we could be seeing monitors, like what the topics could be, not just the corruption, but what topics we think we'll see. Maybe I'll start with you, Ling-Ling. You have some thoughts there.
And preparing for the panel, we all sort of agreed that ESG and greenwashing is an area of potential opportunity for monitorships. I think for a really long time, ESG and any sort of climate-focused activity were really sort of marketing efforts by companies to better position themselves in the market with consumers. But then over time, without sort of regulation, without appropriate review from those internal that need to weigh in on these things, you start to see claims that are just not true, or claims that are really exaggerated in formal corporate documents, like disclosures or reports to regulators, or even documents that could be considered, in that regard, like impact reports or sustainability reports. So I think not all companies have really properly considered the risk there. And when I've spoken to other sort of heads of ESG at other companies, it's only in recent times that they had now the opportunity to review a lot of this literature. So I think that's an area that might be potentially problematic for corporations if they're not being really careful about it.
Other thoughts, anyone?
It goes into that direction. I think we will see some of these developing in the product compliance sphere. I think like coming maybe a little bit from the Volkswagen case, but other automotive companies. What we see in Germany a lot is now kind of product compliance teams and compliance programs being built. And I guess it brings the very same situation as in the FCPA area, that it's a very complex process and the need for various, positions and units in a corporation to work together. A lot of, stakeholders to be served, and a lot of pretending within the corporation and the business making. So I think there will be more need for monitorships in that area. And then secondly, one thing that I've seen without a government involved, but what I found at least very interesting, was the voluntary concept of a monitorship in a 50-50 joint venture situation, where in a, again, anti-corruption exposed area, both global players had put up a joint venture, and in order to force them both to kind of build this joint venture under adequate standards and with the necessary independent oversight, they got a monitor involved from not day one, but very early in the process to kind of be this independent body that on the one hand helps to get the right measures and controls in place, while at the same time reporting to, at that point, two servants in an independent way. And I found that a very kind of good and interesting setup. It was also meant to serve the various authorities that were carefully watching this joint venture, and it kind of gave some credit from day one, right? So interesting development at that end.
So, and we heard this morning about the Department of Justice's program, I guess within the last couple of weeks, or initiative that was issued about in an M&A situation where you can really get credited and not be penalized if you're the acquirer. That actually dovetails with what you just described, right? Because imagine the company that wants to get credit saying, listen, we didn't know what was happening before the M&A or before the JV, but we do now, and we understand that you may have concerns as a partner, so let's bring in this voluntary monitor who will report to you. That can work. I've seen that work in other places. I think we may have, that may expand. But let me ask a question of the audience. Who here is practices in New York? And I know one does. All right, yeah. So you know that there is a model that New York has used for a long time. And that New York has typically had 3 to 4 times as many monitorships as the Department of Justice, right? It's in construction. And so when we look at the expanse of infrastructure around the world, right, different projects, monitorships can effectively be used in construction. In fact, that's where the concept first came up, right? Because the idea was that you have a company that's in the middle of a project, but it's corrupt, but not to its core, just has some problems. You bring in a monitor to fix those problems so that the company can continue doing its work and deliver the big project at the end. I think you're going to see an expansion of that concept. We brought it to Chicago, but I think on a global basis you can see it.
So I'll end by saying that Deputy Attorney General Monaco also, you've heard her say, and the DOJ may not say, sanctions of the new FCPA, so I'm keeping an eye out for that potentially too. I apologize, we ran out of time to have questions, I think, because I don't want to make everyone late for lunch, and Bill, you can tell me if we can take questions. I think we'd be happy to, or supposed to be happy to talk to you too.